Welcome to the second in our series of 4 short videos in which we take a bite-sized look at some of the ways in which litigation and court orders can affect parties who are not participants in the relevant litigation. In today's video, Karla Sheerin-Griffin, an associate in our litigation team, will be reviewing how disclosure orders can affect third parties.
Hello. This segment focuses on 2 of the remedies which are available to a person who has been wronged to obtain information from a person who is not or is unlikely to become a party to the litigation. We will discuss firstly orders for non-party disclosure under Part 31.17 of the Civil Procedure Rules, also known as a CPR, and secondly, Norwich Pharmacal relief. We will also discuss the consequences of failing to comply with an order for disclosure and the steps a non-party should take when disclosure is ordered against them. Once proceedings have been issued, a party to those proceedings can apply to the court for an order for disclosure by a non-party. A court will only make an order for non-party disclosure where the documents the applicant is seeking to obtain are likely to either support the applicant's case or adversely affect the case of another party to the proceedings, and where disclosure is necessary in order to dispose fairly of the claim or to save costs. A court may order a non-party to disclose documents both during proceedings and after judgment. In North Shore Ventures Limited versus Ansted Holdings Limited, the claimants had obtained judgment against the defendants. They believed that the defendants were using trusts to conceal their assets and sought disclosure of the trust documents to assist with enforcement. The court granted an order against the defendants' wives, who were discretionary beneficiaries of the trusts, requiring them to provide disclosure of the trust documents. An important distinction between orders under CPR 31.17 and Norwich Pharmacal relief is that CPR 31.17 only applies to documents. It does not apply to information which is not recorded somewhere. The definition of a document in the CPR is very broad and includes anything in which information of any description is recorded. The definition includes electronic documents, as well as the metadata attached to such documents. Voice and video recordings, BlackBerry messages, electronic documents and servers, as well as electronic documents which have been deleted, would therefore all fall within the definition. In contrast, when granting Norwich Pharmacal relief, which is discussed later on, in addition to documents, the court can also require the respondent to provide an affidavit setting out answers to specified questions. Applications for non-party disclosure are made on notice to the respondent. This means that the respondent will be made aware of the application in advance of the hearing, at which the court will decide whether or not to make an order. Regarding costs, the general rule is that the court will award a non-party the cost of the application and the cost of complying with the order. The court may, however, make a different order, having regard to all the circumstances, including the extent to which it was reasonable for the respondent to oppose the application. In Constantin Media and AG versus Eccleston and others, it was held that the respondents were entitled to the majority of their costs. The court held that the categories of documents in respect of which disclosure was sought were too wide, and it had therefore been reasonable for the respondents to seek to cut them down. In Norwich Pharmacal Company versus Commissioners of Customs and Excise, it was held that where a person gets mixed up in the wrongful acts of others and in doing so facilitates their wrongdoing, whether innocently or not, he comes under a duty to assist the person who has been wronged by giving him full information and disclosing the identity of the wrongdoers. In this case, the applicants owned a patent for a chemical compound. They discovered that unlicensed consignments of the compound had been imported into England, but were unable to discover who the importers were. Although they had a claim for infringement of their rights, they could not commence proceedings, as they did not know the identity of the wrongdoers. The customs authorities were in possession of documents which identified the importers and were ordered to disclose their names to the applicants. Norwich Pharmacal relief is most commonly sought against accountants, trustees and bankers. It is most frequently sought at the pre-action stage to obtain information to assist a wronged party to identify the wrongdoer or to enable them to plead their claim. However, it is worth noting that the applicant is not required to be committed to bringing legal proceedings. The relief can also be used to trace assets and proprietary claims. It is therefore of particular use in fraud litigation. In Bankers Trust Co. versus Shapira, the court granted the claimant's request for disclosure by a bank of information relating to its dealings with the alleged perpetrators of a fraud. The information which the bank was required to disclose included details of payments to and from bank accounts, account balances, as well as correspondence with the defendants and internal memoranda of the bank. However, it was made very clear in that case that the court's jurisdiction to order disclosure in such circumstances should only be exercised when there is a good ground for thinking that the money in the bank belongs to the claimant. It is unclear whether Norwich Pharmacal relief is available to assist with the execution of a judgment. In NML Capital Limited versus Chapman Freeborn Holdings Limited, it was stated obiter that, if such relief is available post-judgment, it should only be available where a non-party has been mixed up in conduct which amounts to willful evasion of execution. An application for Norwich Pharmacal relief should normally be made on notice to the respondent, who will be entitled to attend the hearing of the application. However, if there is a need for secrecy, an application can be made without notice. For example, where a potential claimant is concerned that a third party may inform a potential defendant that the applicant is seeking information regarding his affairs, and that this may lead to the destruction of evidence or attempts to place assets beyond their reach. In such circumstances, it may be more appropriate to apply for Norwich Pharmacal relief without notice to the respondent. The applicant may also seek to include a gagging provision, preventing the respondent from telling anyone about the order, so as to allow them sufficient time to review the information obtained and to consider next steps. There are a number of prerequisites for the availability of Norwich Pharmacal relief. First, the respondent must be somehow mixed up in the wrongdoing. In NML Capital, the court held that the third party must be involved in the furtherance of the transaction identified as the wrongdoing. However, recent case law demonstrates that the court is willing to extend the jurisdiction in the right circumstances. In various claimants versus News Group Newspapers Limited and others, individuals applied for an order requiring the police to disclose information regarding the alleged phone hacking activities of News Group journalists. The court held that the real question determining the availability of the relief is whether the respondent's engagement is sufficient to make him more than a mere witness to the offending act. The court identified a number of factors which meant that the police was more than a mere witness, including the fact that the police had a duty to acquire the information about the phone hacking, had already disclosed limited information to the victims, and had agreed it would not resist an application for further information. Second, the respondent cannot be a mere witness. The mere witness rule prevents a party from obtaining disclosure against a person who could eventually be compelled to give that information in proceedings as a witness. An exception to this rule is where the information which the applicant is seeking is necessary for the applicant to identify the wrongdoer or to plead its claim, and without the information, no proceedings can be brought. Third, the applicant must show that there is a good arguable case that there has been a wrongdoing. Fourth, the relief must be necessary in the interests of justice. The court will consider all relevant factors in deciding whether it is just to grant relief, including the strength of the cause of action contemplated by the applicant, the public interest in allowing the applicant to vindicate his legal rights, whether the information could be obtained from another source, and the degree of confidentiality of the information sought. Fifth, the court will only grant relief where it is proportionate to do so. The court will carry out a balancing exercise, weighing the impact that disclosure will have on the individuals that the information sought relates to, against the value of the information to the applicant. In the Rugby Football Union versus Consolidated Information Services Limited, the RFU issued proceedings seeking disclosure of the identity of individuals who had been involved in the sale of tickets for certain matches. It was held that the interference with the personal data rights of those involved in the sale of the tickets was proportionate in light of the RFU's legitimate objective in obtaining redress for the arguable wrongs. Given the onerous obligations which this relief imposes on third parties, the courts have put in place certain protections. Firstly, regarding costs, the general rule is that the applicant will be ordered to pay the respondent's costs of dealing with the application and any expenses incurred in providing disclosure. Reasonable legal expenses incurred in taking advice on the order are therefore usually recoverable. In addition, the order will generally contain an undertaking by the applicant to indemnify the respondent for any loss suffered in complying with the order. The applicant must provide evidence to the court to demonstrate that it has sufficient funds to compensate the respondent for any such loss. All documents which are disclosed will be subject to an implied undertaking that, without the permission of the court, they will not be used for any purpose other than in the proceedings in question. If the applicant wishes to use the documents for other purposes, including proceedings abroad, he must first obtain the court's permission. Such an application for permission should normally be made on notice to the respondent. The consequences of failing to comply with the Norwich Pharmacal order are serious. An order granting Norwich Pharmacal relief will include a notice on the front page, called a penal notice, which warns the respondent that failure to comply will be a contempt of court. A party who is held in contempt can be imprisoned for up to 2 years, subjected to an unlimited fine, and have their assets seized. It is therefore essential to ensure that the terms of the order are fully understood and complied with. Although a bank has a duty to keep its customers' information confidential, this duty is subject to a number of qualifications. One such qualification is where a bank is compelled under law to provide disclosure. The general rule is that where a bank is required to provide confidential documents or information relating to its customers' affairs pursuant to an order by an English court, the bank will be protected against a claim by their customers for a breach of confidentiality. So, what steps should a non-party take if served with an application or an order for disclosure? When served with an application or an order for disclosure, whether under CPR 31.17 or Norwich Pharmacal principles, it is important to check that the prerequisites for an order are satisfied, review the categories of documents and, if applicable, information that the applicant is seeking to obtain, and consider whether it is necessary to seek to limit or clarify their scope, and consider whether it is necessary to seek to extend the time allowed for complying with the order. In the case of Norwich Pharmacal orders, it is also important to check whether the proposed order contains a gagging provision. For both non-party disclosure orders and Norwich Pharmacal orders, it will be necessary to ensure that documents covered by the order are preserved. It may be necessary to pull server backup tapes and ensure that relevant documents are not destroyed in accordance with the document retention policy. Finally, it is also important to ensure that all documents are reviewed prior to being disclosed.